Hello, everyone. Welcome to this session of the Stockholm Security Conference 2022. We're meeting on Remembrance Day. So it's a day where we remember those who lost their lives in past wars. And we're meeting under the extraordinary circumstance that a war is going on in Europe that may already have claimed as many as 250,000 lives. So it's a sad occasion, really, in order to discuss a topic, the protection of civilians in Ukraine, that's only too real. Now, after 24th of February and the invasion of Ukraine, a growing number of investigations and reports have drawn attention to violations of international humanitarian law that could amount to war crimes, as well as to a deteriorating human rights situation in Ukraine that is directly attributable to the Russian invasion. And in October 2022, the UN Independent International Commission of Inquiry into Ukraine published an unequivocal finding that war crimes, violations of human rights and international humanitarian law have been committed in Ukraine, and that Russian armed forces are responsible for the vast majority of the violations identified. Although the Commission did find that Ukrainian forces have also committed international humanitarian law violations, and that in at least two cases, these could qualify as war crimes. Now in July, a conference organized in The Hague by the Dutch government proposed a dialogue group that would assemble experts who are focused on different aspects of promoting accountability for crimes committed in Ukraine after 24th of February, and that such a group would bring together experts focused on these different crimes, as well as the various instruments that are available to try and make perpetrators accountable. So this session, in a way, is a small contribution, I hope, to such a group. We have a fantastic panel, all of whom are experts in different dimensions of the issue of accountability for war crimes. I'm not going to introduce the panelists individually. We have fairly limited time, but you can find their biographies on the SIPRI website if you look under the Stockholm Security Conference page. I'd like to start by turning to Albina, my sister, who's actually in Ukraine, and joining us from there. Albina, a huge number of people have been displaced from their homes during the war. And that includes people who have been coerced into movement to a particular place. They've been abducted, or they've been given only one alternative when they express the wish to leave their home. What are the main forms of displacement that you would consider to be criminal, and what can be done to track the forcibly displaced, provide them assistance, and try and hold accountable those who forced them to move?
Thank you, Ian. Hello, everyone. I welcome all present participants and online viewers. It's a great honor for me to be invited to participate in this reputable event and to be among the experts on this panel. Significantly, we seek an answer to the extremely important questions, ways and mechanism of protection of civilians in Ukraine together. I'm grateful to Ian and for the opportunity to be here today. I must apologize in advance in case my broadcast is interrupted. My country is going through some of the most difficult times, including in energy sector. So blackouts or disruption in connection have become necessary measures to preserve Ukrainians' energy system during the war. I would like to start with the fact that the full-scale phase of Russia's aggressive war against Ukraine has been going on for 261 days. In violation of the provision of the UN Charter, the imperative principles of international law, the requirements of the ICJ and the European Court of Human Rights, Russia commits numerous international crimes against Ukraine and its civilians. In the middle of Europe, in 21st century, the scale of violence committed by Russia on territory of Ukraine and the occupied territories has shocked the entire civilized world with its cruelty. The civilian population in the temporarily occupied territories in Crimea, Luhansk, Donetsk, Zaporizhia, and Kherson regions continues to be under the military occupation of Russia. So we have yet to learn, document, and investigate the crimes committed by the Russia there. What we can state with certainty today is that Russia is deporting and forcibly transferring the civilian population of Ukraine, including Ukrainian children, from these occupied territories of Ukraine to its territory. And that these acts have become one of the methods of Russia's war against Ukraine, one of the methods of warfare of Russia against the identity of Ukrainian people. In October, President Zelensky said that since the beginning of the full-scale invasion, Russia has forcibly deported more than 1.6 million of Ukrainians to its territory, most of which have been rejected in other escape routes or evacuations, forced to go through filtration camps, subjected to humiliating treatment, forced passportization, separation with their children, and confiscation of Ukrainian documents. So just imagine, Russia has deported at least 7,343 Ukrainian children to its territory. Among them are both orphans and children who Russia has forcibly separated from their families and relatives. According to the available information, these children are then given for unlawful adoption and upbringing in local families on the territory of Russia. And these figures is not final. Unfortunately, it happened in the world of 21st century. International law of armed conflicts prohibits the individual or mass forcible transfers and deportation of civilians in times of war, and criminalize these acts as a serious violation of international humanitarian law, which are included in the list of war crimes. Following the practice of the International Criminal Tribunal for former Yugoslavia, the difference between the two crimes lies in whether a state border was crossed. If so, it's crime of deportation. People were displaced from one part of occupied territories to another. It's a crime of forcible transfer. Also, deportation and forcible transfer are criminalized as a crime against humanity. The elements of this crime are defined by the provision of the Rome Statute, and Rome Statute equate forcible transfer to deportation as a crime against humanity. And such acts as forcible transfer of children from one group to another, which are also committed by Russia against Ukrainian children, can be qualified under the provisions of the Genocide Convention 1948 of the Rome Statute and of the provision of the Rome Statute as an element of the crime of genocide. By the way, in April 2022, Ukrainian Parliament adopted a declaration on the genocide committed by Russian Federation in Ukraine, in which the forcible transfer of Ukrainian children to the territory of Russian Federation, as well as the expulsion from their homes and deportation to the territory of Russian Federation of thousands of persons, were recognized as acts of genocide carried out with the intent to destroy the Ukrainian nation. Similar statements were adopted by the parliaments of 7 states: Lithuania, Latvia, Estonia, Canada, Czech Republic, and Poland. So finding and identifying these children and civilians is very difficult, and Ukrainian authorities have neither direct access nor information about them and how they are treated on the territory of the aggressor state. However, it's still a priority and an extremely difficult step to identify and document all cases of deportation and forcible transfer of civilians, including Ukrainian children. At the beginning of the summer, according to the Prosecutor General's office, more than 20 criminal proceedings on the deportation of Ukrainians to Russia and Belarus were being investigated. And recently, also, the state authorities reported that Ukraine managed to return 69 children deported to Russia. It's important to know that the crime of deportation and forcible transfer of Ukrainian population and children by Russia are not isolated crimes. They are committed in context of other war crimes, crimes against humanity, torture and ill treatment, crime of genocide. Today, Ukraine is defending the rule of law in this war. Therefore, the duty of the international community and the task of the national and international justice system is to bring the justice to justice Russia and its war criminals for committing these terrible and severe crimes against Ukraine and its civilian population. Deported civilians and especially children have to be returned home and reunited with their families. So otherwise, Russia's brutality with impunity puts the rule of law at risk of becoming the rule of force. Thank you for your attention.
Well, thank you, Albina. I'd like to turn next to you, Ingrid. Conflict-related sexual violence, of course, has been a persistent feature of conflicts around the world. And this form of violence is described as instrumental in achieving military and political war aims rather than being an emotional act. The recent conference in Warsaw of the human dimension of the OSCE drew attention to the fact that Ukraine is no exception to this. We also have conflict-related sexual violence reported. What's the scale and nature of the sexual violence that's been reported in Ukraine, and what's being done to address that form of crime in Ukraine specifically, but also more widely in conflict areas?
Thank you, Ian. Good morning, everyone. It's an honor to be here and to contribute in a small way, at least, to the discussion and the incredible work that's happening in Ukraine to tackle some of these crimes. So what do we know about conflict-related sexual violence in Ukraine so far? And I would start with a caution. Accurate figures for prevalence and an accurate understanding of the needs for response can be difficult for conflict-related sexual violence in particular. And this is for many reasons, including non-reporting due to lack of trust, lack of safety, social and self-stigma, population displacement and movement, among many other barriers. We also know less about what's currently happening in occupied territory due to the dangers of reporting and the lack of access there. We do have good reporting and documentation of the patterns of conflict-related sexual violence in occupied territories from 2014 to 2015 in particular, and that pattern can be informative of and certainly resonates in some of the recent patterns since February. Those patterns included conflict-related sexual violence against women and men in detention centres, such as rape in all of its forms, including multiple perpetrator rape and sexual slavery, sexualized torture, including attempted castration, collective humiliation with sexualized elements, forced witnessing, and threats of rape or other forms of sexual violence against family members, and reported specific incidents such as a girl under 18 being given as a gift to frontline Russian soldiers, and the beating of pregnant women to induce miscarriages. Since the 24th of February, we have some reporting of conflict-related sexual violence by media, by justice actors, by human rights documenters, and by different monitoring and human rights missions, including the UN Human Rights Monitoring Mission in Ukraine. It appears to be happening in two different main circumstances. The first is as part of attacks or occupations of villages and towns, particularly by certain units and forces. Typologies include rape in all of its forms described above, and in particular sexual slavery. There are reports of women being rounded up and held for the purposes of sexual violence and rape for days or even weeks in basements or in houses in their own villages and towns. There's forced witnessing of sexual violence against family members and forced nudity in public against both men and women. The second set of circumstances that we know about is specifically against men being detained in occupied territories. Specifically, this includes various forms of sexualized torture, such as genital electrocution, genital beating, threats of sexual violence against self and against loved ones, and as the UN monitoring mission described, unjustified cavity and body searches. That would amount potentially to forced nudity in terms of the body searches and rape in terms of the cavity searches. So what do we know about the scale? That's a little bit about the sort of typology and the nature of it. What do we know about the scale? We do know that it has been reported across numerous geographical locations, from north of Kiev earlier this year to the south more recently, where occupied territory is being liberated. But we are still in the dark and may remain so about numbers. There is a recognized and acknowledged underreporting and delayed reporting occurring, and an affected population that is displaced and on the move to safety. Even after territory is liberated, often population then begins to move after liberation or as part of liberation, with fear of Russian troops retaking territory. The Office of the Prosecutor General has spoken of investigating around 40 to 45 individual incidents of sexual violence since the 24th of February. The UN Human Rights Monitoring Mission has documented 43 cases of sexual violence up to the end of July, and have verified a further 13 cases up to the end of October. These numbers seem small compared to the reports that we have, we see in the media, etc. One research survey that might actually shed more light on the level of prevalence is a research survey that was conducted in April 2022, and it asked 1,000 Ukrainians crossing the Polish border about sexual violence. 93% had heard that sexual violence had occurred in their area, and 20% had either specifically witnessed sexual violence themselves or knew someone that sexual violence had happened to, or they'd been subjected to it. And this certainly suggests a higher prevalence than the reports we currently have. Ian mentioned sexual violence being used as a policy or as a weapon of war. And certainly to date, there are suggestions that it is systematic and being used as a weapon of war. But most people are still calling for more data and analysis to try to really understand the mechanics behind it, or the dynamics. I would refer here to the excellent work of Professor Elizabeth Wood, who distinguishes between conflict-related sexual violence as a policy versus conflict-related sexual violence as a tolerated practice. There's certainly, much more work that can be done and needs to be done to really understand what's happening. What we do know is enough to understand that there's a need for acute and long-term survivor-centered responses, both within Ukraine and wherever Ukrainian populations end up in safety. And it's not just for women, it's not just women who need this help. For example, one of the reported victims has been an 11-year-old boy, and there's obviously reports of conflict-related sexual violence against men as well. Our holistic responses need to be attuned to gender, age, and other factors, intersectional factors. So very briefly, what is being done? I hope we'll be able to have a broader discussion about some of the challenges, etc. later, but what is being done? And before I highlight a few short kind of headline initiatives, what I would like to say, and I think Albina's contribution earlier, it shows this very well, that all of the Ukrainians that I've spoken to or had the privilege and honor to work beside recognize the importance of these values. They're prepared to recognize and face the challenges, tackle the challenges, and are absolutely determined to get this right and to do their best for Ukrainian citizens and their country. It's an absolute honor to work with such motivated, determined colleagues. So in 2018, before the most recent invasion, in collaboration with UN Women, the government had already published a cross-government Ukrainian conflict-related sexual violence response strategy. There is now also within the Office of the Prosecutor General a specialist unit for conflict-related sexual violence within the war crimes team. This is led by an experienced and determined prosecutor who has herself adopted her own accountability focused conflict-related sexual violence strategy, and is now working on an implementation action plan and framework to coordinate and deliver the considerable amount of work and needs in this area. This is a cross-government initiative working with civil society to try to build systems, access points, and processes which are safe and effective for survivors to access justice. There's also been a repurposing of recently established specialized domestic violence teams. These have been mobilized into joint mobile teams that are focused on specifically on conflict-related sexual violence. These teams include both prosecutors and investigators working together and are able to mobilize to key strategic areas, particularly newly liberated territories. There's also been considerable international assistance and tools which are being made available to Ukrainian actors to adapt and ensure that they work in the Ukrainian context. There's a lot of coordinated support from many international actors, including the UK government's Preventing Sexual Violence in Conflict team of experts, the UN team of experts for the rule of law and sexual violence in conflict. The EU, its assistance mission has a CRSV component, and the ACA, which is a joint UK, US and EU initiative, is working directly with the Office of the Prosecutor General on strategy, mentoring and collaboration on war crimes, but also including conflict-related sexual violence. Separate from all of that, there is judicial training occurring to make sure that it's a whole of system approach in terms of being prepared and ready, able to do these cases in an effective and safe way. I'll hand it back to Ian now. Thank you.
No, thank you so much for that very, very comprehensive overview. And I'm sure we will return to many of the points that you've raised in the conversation among panelists. But I'd like to turn next to Ebony. I mean, the displacement that was mentioned earlier includes the movement of a lot of people out of Ukraine, and that includes victims and also perhaps perpetrators. Now, Sweden is one of the countries which is exploring the use of universal jurisdiction or crimes of universal jurisdiction to prosecute individuals for crimes committed outside Sweden. And I think it's one of a number of European countries that's exploring that instrument. Could you describe the work that's being done in Sweden and with European partners to use the instrument of universal jurisdiction?
Sure. Thanks, Ian, for the questions, and thank you for the opportunity to be part of this distinguished panel. As I'll talk more about later, I think that discussions like this one today and your whole conference, these opportunities to learn about each other's work and the various initiatives going on in Ukraine are incredibly important for coordination efforts, given everything that's been going on. So I'm very glad to be here today. So I'll start with a brief overview of universal jurisdiction and focus specifically on two recent cases in Sweden that my organization has been monitoring and reporting on, and that have really helped to define and establish universal jurisdiction as an important legal principle in Swedish law. And then I'll talk more specifically about the investigation that the Swedish Police War Crimes Unit has opened into possible war crimes committed in Ukraine. And focus more on that. But to begin with, universal jurisdiction, what is it? In short, it enables states to assert criminal jurisdiction, that is to investigate and prosecute certain grave international crimes, including war crimes, crimes against humanity, torture, and genocide, many of the crimes that we're seeing now in Ukraine, even if they were committed abroad by a foreign national against other foreign nationals. And this is based on the principle that some crimes are just so serious, so egregious, that they must be punished no matter where they were committed or who committed them. The Geneva Conventions, for example, as well as a number of other international treaties, actually require states party to investigate and prosecute grave breaches. So in other words, some international crimes are so serious that states have a duty to ensure that they don't go unpunished. But as important of a tool as this is for those of us working on accountability, in many ways, universal jurisdiction should be seen as a last resort after domestic and international prosecutions, or at least complementary to them, just based on the idea that crimes should be prosecuted as close as possible to where they occurred, so that victims and witnesses can more easily participate in the process, and the communities most impacted by the crimes are a part of the accountability process. But at the same time, of course, as we know, this is not always possible. And in these situations, universal jurisdiction can be a particularly important tool to seek accountability in situations where, for whatever reason, prosecution in domestic courts is unlikely. Perhaps there's no functioning independent legal system, or the political situation is such that a perpetrator would never be brought to justice. And looking at the cases that have been prosecuted in Sweden, let's take, for example, Syria, where it's virtually impossible that crimes committed by authorities would ever be prosecuted domestically in Syria. So seeking justice in European courts is one of the only options available to victims. And in recent years, we've seen a number of cases brought against Syrian nationals accused of war crimes in Sweden, and most recently in Germany this summer in the Koblenz trial. On the two cases in Sweden, actually both of them this year, the first one, so Swedish law recognizes universal jurisdiction over certain grave international crimes, meaning that Swedish courts can prosecute crimes committed on foreign territory by foreign nationals, of course, with certain conditions and limitations. One of the biggest trials recently wrapped up in the Stockholm District Court this summer. It was a case brought by the Swedish prosecutor's war crimes unit against an Iranian citizen who was suspected of participating in mass executions and torture of political prisoners in Iran in the 1980s. In July, the defendant was actually convicted and sentenced to life in prison, although he's now appealed, so that's pending. And we're also awaiting an upcoming case that should hopefully start soon, also in Stockholm District Court, against the executives of a Swedish oil company called Lundin Oil. Lundin Oil operated in what was then Southern Sudan, now the country of South Sudan, in the mid-1990s and early 2000s. And during this period, Sudan was embroiled in a violent civil war. And right now, the former CEO and CFO of Lundin Oil stand accused of aiding and abetting war crimes committed by the Sudanese regime, war crimes committed in order to secure the area of oil operations. The most recent event in the trial is that one of the defendants, who is a Swiss national, not a Swedish national, argued that the Swedish courts don't have jurisdiction to prosecute him. In Sweden, for universal jurisdiction to be exercised, there should be a clear and legitimate interest in prosecuting the defendants. However, just this week, just a couple of days ago, actually, we were glad to get the news that the Supreme Court ruled that the trial can actually proceed, finding that the defendant was acting as an agent of a Swedish business, and that this is a sufficient interest to justify the prosecution going forward. Now, turning to Ukraine, of course, the options for justice in Ukraine look quite different from Syria or Iran or South Sudan for that matter. For the main one being that Ukraine actually, as we've been talking about, has a functioning and effective legal system. They have a prosecutor's office that is working to investigate war crimes and a criminal justice system to prosecute the perpetrators. And while there may be an overwhelming amount of evidence and reports of crimes to process, the structures and systems needed to prosecute these crimes are in place, along with a strong will within the country to prosecute the crimes and seek accountability. Moreover, the International Criminal Court is investigating crimes on the ground in Ukraine and will certainly prosecute many cases. There are also discussions about hybrid tribunals and other judicial mechanisms. So in short, there are a number of options for seeking accountability for the crimes being committed right now. So in the case of Ukraine, your universal jurisdiction cases brought in other countries would serve more of as a backup option or a complementary option to domestic and international court prosecutions. And briefly about what's going on in Sweden, the Swedish Police War Crimes Unit has opened a structural investigation. So they're looking into possible war crimes committed in Ukraine since February of this year. And their hope is to secure evidence and witness testimony that could be used either in Swedish courts or in international or Ukrainian courts. They don't have, it's a structural investigation, so they have not identified any specific perpetrators at this point, but they're urging victims and witnesses to come forward and provide testimony. They also cooperate with Europol and other international investigations to promote sharing of information and evidence gathered. And from meetings with them, they have faced a few challenges, just a few practical ones, that Sweden hasn't seen as many Ukrainian refugees as initially predicted, most likely due to distance, and that Sweden is not as obvious or as easily accessible a destination as, for example, Poland or other neighboring countries. Freedom of movement within the EU also makes it difficult for the police to track who is here. Ukrainians can enter the country freely as visitors and stay for an extended period of time. And while the police, of course, work with the border police and the migration agency and other authorities, it really depends on witnesses coming forward and voluntarily providing information about what they've seen. And related to this, going to a foreign police force to report a crime that happened to you in a different country is perhaps not your top priority when you've been forced to leave your home, especially if you see coming to Sweden as a temporary situation, which many Ukrainians here do. People suffering from trauma, people trying to establish their families in a new country, they have other priorities and likely don't even know that going to the police here and reporting a crime that occurred in Ukraine is an option for them. Or perhaps they prefer to report it to the Ukrainian authorities when they return. But in any case, these are some challenges that we're seeing in the investigation here, although the police are well aware of them and are working hard to expand their outreach and awareness efforts. And as I mentioned before, there's a number of reasons, especially in the case of Ukraine, why universal jurisdiction might not necessarily be the first option for prosecuting crimes committed in Ukraine. A couple of practical issues, such as the distance for victims and witnesses to travel. With Ukraine, it might not be as great of an obstacle as, for example, with South Sudan, but there's still a separation between the location of where the crimes occurred and where the victims would have to travel to Sweden to testify. There's also a practical issue of finding a perpetrator in this country. In almost all of the other war crimes cases brought in Sweden, the defendant had been living in the country. And only in the Iran case that I mentioned was the defendant living abroad, and he was actually lured into coming to Stockholm to visit. So it's not especially likely that higher level perpetrators in particular would travel abroad and then reveal enough information to enable authorities to identify them. Of course, these will be issues in any international trial, including cases prosecuted at the International Criminal Court. It's not actually located in Ukraine. And if there's a hybrid tribunal or any other judicial mechanism, those will take time to set up. So for these reasons and others, it's critical that the international community continue to support and strengthen the Ukrainian prosecutor's office to enable them to expand their investigations and to manage the huge volume of cases coming in. I'll stop there for now, Ian.
Right, thank you so much. Yeah, I think it's a very compelling case for strengthening European cooperation in the judicial system, in the area of investigation as well. Fred, I'd like to turn to you next. It's no secret, I think, that the OSCE is under great strain, but some of the instruments which the OSCE makes available are nevertheless being used. I mentioned earlier the possibility to convene the Human Dimension Conference in Warsaw, for example. Now, the Moscow mechanism is another instrument that's drawn attention to crimes committed in Ukraine. There have been 2 reports, and it was also previously used in Belarus. And the Moscow mechanism has not only reported on violations of humanitarian law and human rights, but it's also drawn a link between domestic practices and what we're seeing in conflict locations. Just explain to us a little bit about the Moscow mechanism, how it works, what it's been able to accomplish in Ukraine, and perhaps how it can help generate political accountability as well as accountability in front of the criminal law.
Well, thank you, Jan, and thank you for inviting me to contribute to this very interesting panel, most timely panel today. Yes, you're right. Moscow mechanism is probably not very well known outside, certainly outside the OSCE community. It's a child of the early 1990s, a period when Cold War came to an end, time when optimism prevailed as to the protection of human rights, both on a state and civil society level. And I think this mechanism was part of the spirit of the Helsinki human rights movement. So I think it really goes back all the way to the Cold War legacy of Helsinki, and has not, as you mentioned, has been used more recently quite a few times. I think the key element of this mechanism is that it is basically a non-consensual arrangement of the OSCE. There are very few non-consent-based arrangements. And of course, the fact, as you mentioned, that the OSCE is in quite almost like in a coma right now is linked, of course, to the continuous veto being put down by Russia on the budget, on the mission extensions, on new leadership elections, et cetera, et cetera. So I think this, in this sense, this Moscow mechanism stands out. It can be used. It basically provides the possibility to establish an ad hoc fact-finding mission of independent experts to assist in the resolution of a specific human rights issue. And that human rights issue can be in your own territory, or most interesting, of course, in the territory of another OSCE state. To be launched, this mechanism needs the support of at least 10 invoking states that are required to address, here I quote, a particularly serious threat to the fulfillment of the provision of the OSCE human dimension. So basically, looking back over the last 30 years, that tool has been used 12 times so far. And the usage and mandates are reflecting the evolution of conflict propensity and human rights protection across the OSCE over these last 30 years. For instance, the Moscow mechanism has been used in the Western Balkans during and after the Yugoslav wars. 1999, Russia activated the mechanism in relation to NATO's military operation in former Yugoslav Republic. And more recently, also as you referred to, there has been a mission because of the serious human rights violations by the Lukashenko regime linked to the fraudulent presidential elections in Belarus in 2020, but also a mission, a Moscow mechanism, fact-finding mission in case of the repression against LGBTI persons in the Chechen Republic of Russia as well. Just to give you a few examples, and of course, most of these cases where states under investigation were not prepared to cooperate and refused to cooperate and declined respective rapporteurs access to their territory by denying entry visas. And in many of these cases, then the mission had to fall back to remote investigations and were often deprived of primary sources and informal information. Now, with regard to Ukraine, there have been actually 3 Moscow mechanisms over the last year, this past year. And 2 of them were fact-finding missions about violations and abuses of international human rights law and international humanitarian law and war crime in Ukraine. All of these laws and legal commitments have been retained in the numerous documents of the OSCE over the last 30 years. So it is a legitimate ground to engage in this kind of investigations. There was also an expert mission to review human rights situation in Russia this year, actually in September, very recently. And I have no time to go into that, but I'm happy perhaps at a Q&A to come back to that. So the first fact-finding mission to Ukraine has been decided 2 weeks after the Russian invasion And this was related to news emerging from the front about atrocities, especially the bombardment of the city of Mariupol. 45 of the 57 OSCE states voted in favor of such a mission. In favor, and quite interesting, of the mission were also countries like Moldova, Georgia, Serbia, and Turkey, plus all EU and NATO states, but not Russia, Belarus, Central Asian countries, and Southern Caucasus, except Georgia. So the fact-finding mission was made up by 3 experts. Usually these experts are from smaller states, neutral states. I mean, in this case, it was like eminent personalities and experts from Austria, Czech Republic, and Switzerland. The problem was the timing of the delivery of a report in the context of this investigation is very short. The Moscow mechanism does not give more than 3 weeks within which a solid and credible report should be submitted. And also in this case, in this first mission in March, the OSCE then advised the experts not to travel to the Ukraine because of duty of care problems. Experts could have been exposed. You may remember at the time Kiev was actually threatened from the air and from the ground. So I think again, this team had to conduct online interviews and sort out through evidence from numerous sources, including open sources material and accounts from human rights and nonprofit CSOs. So what were the findings? And again, I think a lot of them are very close to what Albino and Ebony have been referring to. Russia violated international humanitarian law by deliberately targeting civilians, and the attack on maternity hospital and the shelter with civilians, actually, which has been a theater before, in the besieged city of Mariupol amounted, according to the report, to an act of war crime. The report also noted Ukraine's role with allegations of abuse, in particular on the quote about the treatment of prisoners of war, originally considered criminals, and treated in ways that are not incompatible with the Geneva Convention. Now, the second report, I'm not going into details on that. It's interesting to see it's a different team. Again, three persons. So actually, the credibility of the second report in validating the findings of the first is, of course, much better if you have different persons who are sent to such a mission. But this time, the members were able to go into Ukraine, and visited also the towns of Irpin, Bucha, and Hostomel. Some of the most serious violations cited by the second report include targeted killings of civilians, including journalists, human rights defenders, local mayors, unlawful detentions, abductions, and enforced disappearances of such persons, as we heard already before, large-scale deportations of Ukrainian civilians to Russia. Now, to conclude, how can the Moscow mechanism be made more effective? I mean, we have seen the 2 reports, which are quite detailed. I mean, over 100 pages. I encourage you to look at them. They're published on the OSCE webpage. They have to be published according to the mechanism. But what could be done more? Well, first, we know that the Moscow mechanism is relatively easy to trigger because you need only 10 states out of 57 to trigger that mechanism. The establishment and implementation cannot be blocked by lack of consensus. Again, nobody's a veto right for this kind of mission, and it has to be published. But what else could be done also to include more political accountability? So I think the easiest is, again, the mechanism should be used much more. Again, because it's easy and it really can put the finger on the sensitive issues. The report should be presented to the Permanent Council, which meets every week on the level of ambassadors, and be submitted to discussion to the annual Human Dimension Implementation meeting, which you, Jan, already referred to, the HDIM, as it's being called. One could also improve the procedures to share the findings with the International Criminal Court, national courts, and others that have jurisdiction over alleged war crimes and crimes against humanity. but also civil society organizations and human rights NGOs. And finally, to present the findings of the report also to the United Nations Security Council meeting dedicated to Ukraine. There are quite a lot of them. And if that's being blocked by Russia, then the ARIA formula meeting, ARIA formula could be used to present such reports as well to United Nations. Okay, with this, I'd like to stop here, Jan. Thank you.
Okay, no, thank you so much, Fred. It's a very interesting instrument. And I think we've heard some of the challenges as well across the different presentations of collecting information, providing information that can be used as evidence in circumstances where there may be no physical access. And with that, I'd like to turn to you, Nate, really, because that raises the question of how these tools could be sharpened or supplemented with the technology that's increasingly available. It's a very interesting topic, how various different technical solutions can be applied. I actually started thinking about it, though I haven't really had a detailed involvement, already in 2014, when you had this occasion in Ilovaisk where Ukrainian forces were given what they thought would be free passage from Ilovaisk, and then when they used the safe corridor, they were killed. And the question was whether they were killed by local so-called volunteer forces or whether there was direct involvement by the Russian military. And that was the first time I can remember these kind of social media, commercial satellite, various technical tools being applied. Now you've been very active in Yale Humanitarian Research Lab in thinking about how technology can be used to document alleged violations of international law. Can you describe for us how the Conflict Observatory works and how it's being used in Ukraine? And how could some of your findings be linked to the legal processes that the other colleagues have talked about?
So building off Ambassador Tanner's comments, the Conflict Observatory's first two reports from the Yale Humanitarian Research Lab were specifically in support of the Moscow mechanism. And so from the beginning, in our initial mandate was to support the specific accountability mechanism and reporting mechanism that Ambassador Tanner described. And our first report, which was completed for round one of Moscow mechanism in April, was documentation of alleged attacks on hospital facilities in 5 oblasts. We documented 22 incidents of hospitals being apparently hit by Russian bombardment in the first month of the war. And then in the second Moscow mechanism, we documented using commercial satellite imagery and open source information damage to schools and hospitals in Severodonetsk rayon. Since that time, and I'll go in more detail in a moment into how our methodology works, but since that time, we have on the Yale team, and there's multiple teams that are part of the Conflict Observatory, including the Smithsonian, Planetscape AI, and other research teams will be joining soon. And it's supported by the United States Department of State's Conflict Stabilization Operations Bureau. And so for those of us on the Yale team, after Moscow mechanism over the past few months, we've worked on 3 major reports. One is identifying facilities that are part of a system of filtration operations in Donetsk Oblast. We've identified 21 facilities, which can include registration points, can include initial temporary holding camps, interrogation sites, and then penal colonies for long-term detention, primarily of military-aged men. We also identified in that report what appears to be disturbed earth at Olenivka prison, where there was an alleged death of over 50 prisoners in July from an alleged explosion of unknown origin. we identified at that facility prior to the explosion indications of activities consistent with reports that prisoners were being used to dig graves. And that was through commercial satellite imagery with some open source information. And then after that, we worked with Oak Ridge National Lab from the U.S. Department of Energy to build a computer vision model to identify silos, elevators, and other crop storage facilities in satellite imagery in Ukraine. And using data provided to us from the U.S. Department of Agriculture, originally from the Ukrainian Grain Association, we were able to identify 76 large-scale and small-scale grain storage facilities that appear to have been damaged or destroyed. And then recently, we documented the alleged mass grave in Izium and identified Russian excavators on the site and documented growth of that alleged grave operation around this cemetery on Shakespeare Street in Izium. So we've been doing damage assessment using imagery and open source. We've been identifying filtration facilities. We've been documenting mass graves, and we've been corroborating damage to crop storage facilities. We've been doing that directly in support of Ukrainian domestic prosecution through OPG, the Office of the Prosecutor General, and also in coordination with other international mechanisms, which there will be more information about soon. What I want to say here is that these methods, we've been using them. I started using them in Afghanistan in approximately 2009. We used them at scale with George Clooney's support as part of the Satellite Sentinel project when I was at the Harvard Humanitarian Initiative in Sudan, South Sudan. So these approaches are, depending on how you measure it, now almost 14 to 15 years old. But what's new here in Ukraine is the sheer scale of available data is unprecedented. And more important than the data is the support of governments to use this as a formal forensic means of support for domestic and international prosecution. In that sense, Ukraine is a watershed moment, not because of the methods, but because of the money. Over.
No, thank you so much. I wonder if I could come back to you, Ingrid, with this mention of governmental support for these various initiatives. And we've actually, obviously, in this panel only scratched the surface of all of the different types of crime that are being committed and all of the different actors who are involved in trying to produce accountability. But I mean, the UK has taken a lead in trying to raise the salience of these issues to a higher level through high-level political events. What would you say could be done to kind of bring all of this together and create a critical mass of international cooperation to promote accountability? How is the UK taking that forward?
Thank you, Ian. So I'm a member of the team of experts for preventing conflict-related sexual violence. And my involvement is much more on a technical level than a political level. So I probably have less to say specifically than some of my colleagues in the FCDO that could talk about this. But I am aware of very high level support being given, but also making sure that the evidence that is available, as Ambassador Tanner mentioned, is put before the Security Council, that is put before the Human Rights Council within the UN. The UK is about to host a conflict-related sexual violence conference at the end of November, and there's obviously a huge attention specifically on Ukraine during that conference. And it will be a great opportunity with various different members of governments and civil society there to talk further about how to coordinate. I think there are lots of different mechanisms and lots of different ways to actually bring accountability for Ukraine, particularly given the activity within Ukraine and the very active and very determined prosecutor's office and law enforcement there. But as Ebony has pointed out, there are other opportunities in other places and a very transient population moving to safety. And so actually that level of coordination is deeply needed as evidence is gathered in many different locations. There is, my background is as a prosecutor, so I can't help but think about, not competition for evidence, but basically duplicative cases, etc., and making sure that actually we're doing, the cases are being done in the best way possible, in the best location possible. And I think that's something, governments got together at the Dutch conference, and I think more of that needs to take place. I know the UK is coordinating with other like-minded governments that are also pursuing this, and I know the US have been very active. So as I mentioned before, one of the key coordinating initiatives is the ACA, which is working both inside Ukraine, but also will help coordinate both assistance going in, but hopefully this coordination around evidence. And I'd also mention, I think there's another critical player in this, which is the EU Genocide Network. So the EU Genocide Network is a network of national prosecutors within war crimes units around the EU. And they work together to try and coordinate on cases. And also within the EU can do joint investigative teams, which one already exists in relation to into what's happening in Ukraine. So it's important to recognize all of these different kind of clusters of coordination and to coordinate the coordination, if that makes sense as well, given the amount of interest. And as Nathaniel said, how much money and support there is, really translating that into very coordinated, productive and amplified effects rather than the risk of duplication.
Thank you. Albina, maybe I could come back to you and ask you about the perspective in Ukraine on these issues of balancing accountability with victim support, if you like. Ebony mentioned that there are many people who have been victimized, but who nevertheless essentially want to move on with their lives rather than subjecting themselves to legal processes. What would you say is the sense inside Ukraine of the importance of these accountability mechanisms and making sure that they're properly resourced?
Thank you. And first and foremost, yes, I'm completely agree with Ebony that Ukrainian judicial system, and it's the primarily responsibility to seek accountability of these severe violation and crimes, and the existing international mechanism could support it and just to help to make the offenders stand before the trial or go through the tribunals, different that. But what we see in Ukraine also is in parallel to seek the accountabilities of violence, is also the process of developing the system which helps the victims of these crimes, especially, for example, victims of sexual violence related to conflict, to build up these medical services, psychological services, which would be very not accountable, but useful for the victims. So it's, for example, in September, the Parliament voted for the creation of the Special Inquiry Commission on the investigation of the cases of facts of sexual violences. And as a part of this process of the Inquiry Commission is also the drafting how status of the victims of the sexual violence. So how to help this person who survived after such severe crimes committed by Russian forces. And yeah,
it's very difficult to establish the connectivity, of course, with Ukraine. So we lost you there, Albina, just for a couple of moments. The screen froze.
You hear me better possibly now?
Yes, actually, maybe to complete your remarks without the camera would be one way to do this.
Yeah, what I want to say in concluding that we have like two processes. The one is to make accountable all their crimes and to collect all the information about the person who survived or who are the victims of these crimes, and also to develop a system and services how to help such a person. Among them are the group of risk are the victims of sexual violence, and the group of risk is also children and persons with disabilities and mothers with children, etc. So it's a complicated process.
Yes, so I would suggest that as part of this dialogue group, which this very interesting concept that was mentioned in the July conference in The Hague, the issues of accountability also need to be balanced with, in equal measure, with international cooperation to think about victim support, how it can be organized most effectively, and how international cooperation can provide the necessary resources and expertise. I don't know if there are any questions that the panelists would like to pick up, which have been raised that they'd particularly like to highlight during the discussion. I don't think it's going to be easy to summarize this discussion. But where do you think the next steps should be in working to develop the various tools and instruments? Red, please.
Yeah, thank you. I personally would be interested also to see a bit more comprehensive mapping of all the activities in Ukraine, who is doing what, particularly in this field we are now dedicating this panel to, because again, there's a legal aspect, there's a humanitarian aspect, there's a political aspect too. And of course, what Nathaniel has referred to, all the work being done, of course, also by non-governmental organizations is extremely important. And I just know that from the OEC side, ODIHR, which is the human rights agency actually of the organization, they have a network which reaches into Ukraine, of course. But again, it may not be sufficient for the experts who do then write a report and to have reliable resources, but also then to share the findings with the partner organizations. I don't think that so far there's a network which would assure this kind of continuation. And from the OEC perspective, I mean, again, I'm not with the OEC anymore. I don't represent the OEC. But one question, which of course is open when it comes to all the findings, is what you do with them. Again, the Moscow mechanism has no language on, let's bring it to the ICC or to New York or so. I mean, these are questions which are still open, and I certainly would look forward to any kind of suggestions on that.
Yeah, one of the things which has been very discouraging to see in the OSCE context has been the progressive closure of the national missions. As their mandates have come up for renewal, they've usually been blocked. So they're one by one being discontinued. But under the Polish chairmanship, actually, this special project on Ukraine was one thing which could be established. I don't know if this special project on Ukraine would be a place where the type of coordination and mapping that you were talking about could take place.
Yes, I think so. I think it's a good point. I think there's also an inherent relationship between the Moscow mechanism and this Ukraine support program, because that program is also based on non-consensus arrangements, which every state needs to put in their own funding. There's no unified budget available for that, but we talk now about almost 30 million euros, which are committed to that project. And so I think there must be, of course, more like the civilian side, humanitarian side, but also I agree with you, the coordination efforts among like-minded organizations would be certainly an important task to do.
Yeah, thank you. Please, Nathaniel.
I think it's important for me every time we talk about Ukraine to make this statement. The level of international engagement and data support, capability support, monetization is unprecedented probably since International Criminal Tribunal Yugoslavia and accountability for crimes in Bosnia in the 1990s. And so this is a watershed moment, regardless of what happens next. It's important to say that we have an obligation to make sure that what we're doing in Ukraine is not a one-off, but is a precedent setter as it relates to other situations in the world where justice, an equal level of justice, is required as well. And that includes Syria, that includes Ethiopia, that includes South Sudan, Yemen, the list goes on. And so really the question here is, how do we take this unique moment we have and use it to build precedent in a way which doesn't create disparities in terms of available justice? And the last point is this, is that looking at double IM and triple IM, the mechanisms for Myanmar and Syria in terms of evidence collection and storage, a similar mechanism may be required here. And additionally, the question of coordination, particularly on retention of alleged evidence, digital or otherwise, to a standard chain of custody is an urgent requirement. And so these are the two last things. How do we make this a precedent setter? And the other is, how do we create a repository for this evidence with coordination, because this will go on for years. Over.
Thank you so much. So that's actually a point that was made when we had this conversation 12 months ago, that many of the discussions are sort of context specific, that we talk about Syria, we talk about Ukraine, we talk about conflicts in African countries, but looking horizontally across the conflicts and creating a kind of critical mass behind this topic. I think it is really time. Ingrid, please.
Thank you. I just wanted to supplement what Nathaniel said. There's a real tension, I think, at the moment between the sense of urgency, and it's a sense of urgency around, response, deterrence, prevention, and also this moment in time, as Nathaniel's talking about, like this huge international interest and money being available, that things need to get done now, and this massive sense of urgency. But that stands in quite stark tension with the reality, which is that we need long-term. This is not just an acute need. There needs to be long-term support here. There are systems to build. There's capacity to build. There's practice and attitudes to change within systems in order to respond safely in a survivor-centered manner. So there's a lot of work to be done over time. And I just want to emphasize that this moment in time where we have all of this attention needs to translate into longer term support, and that we can't just get caught in this urgent moment to collect evidence and have trials immediately when there's a system and a set of actors who are not necessarily ready to do that in a way that is safe for survivors. If we look specifically at conflict-related sexual violence, we know there is delayed disclosure. We know that there's a problem with trust, both between civil society and survivors, and a system which is not ready for them, and previously has perhaps let them down when it's come to wider forms of sexual violence. and Ukraine isn't unique in that. Most court systems, most justice systems fail survivors. So we have to recognize that in order to build that trust, in order to actually get accountability for crimes like conflict-related sexual violence, that will take time, it will take prolonged interest, and it will take prolonged support and international interest.
Thank you. Yes, I mean, last time we discussed this, we were talking about the tragedy of Syria. Now we're talking about the tragedy of Ukraine, and it really does speak to the need to build a system rather than have isolated and separate conversations. Ebony, please, I'm also a bit conscious of time. We're coming up to the point where we'll have to close because the technical team will need to prepare for the next session. But please, some final remarks.
Sure, I just wanted to actually echo Ingrid and everyone else's concerns and support the idea of the need for increased international cooperation. I also, like Ingrid, come from a background as a prosecutor and share her concerns about overlapping or duplicative efforts and the need for coordinating the initiatives going on. On the one hand, it's great that there are so many efforts to collect and preserve evidence and gather testimony and investigate crimes really as soon as they've happened. These are things that are quite unusual in international prosecutions. But at the same time, as people have talked about, there is a risk that with so many initiatives going on, victims may be interviewed multiple times by different people, by different organizations, for example, which leads to not only potentially conflicting statements that would later undermine a court case, but also to re-traumatizing victims, who are asked to repeat their stories over and over again. And there's also a need to ensure that the people actually in the field interviewing victims, especially victims, particularly vulnerable groups like child victims, or as Ingrid mentioned, survivors of conflict-related sexual violence, that the interviewers have the appropriate background and training needed to ensure that the interviews are conducted in a sensitive and appropriate manner. There's a huge focus on accountability and ensuring justice for Ukraine, and rightly so. But those of us involved in these efforts just need to be sure that in our eagerness to promote accountability, that we don't end up undermining the process.
Yeah, it's a point well taken. So we're coming to the end, and I'd just like to thank you all for joining this conversation and for being able to conduct what's a very difficult topic in such a professional way. And to thank you all really for the efforts that you're making individually. Everybody on this panel is working very hard to address this problem, and enormous respect for what you're doing, and wishes that you'll be successful. So with that, again, I'd like to thank the audience as well for joining. We've had really very good attendance in this session. I hope it's been useful, and I think it's a conversation which we have to continue as we try to move from where we are now to building this more efficient system that we've all talked about. So thank you once again, and with that, the session is closed.